Welcome to the third video in the Copyright and Intellectual Property series on copyright in Canada. Copyright in Canada is covered by legislation. To be more specific, the Copyright Act of 1985. The most recent update of the Copyright Act was in 2012 with the Copyright Modernization Act, which is very popular in the glam sector, and so you'll hear about this one a lot. Why is this so popular? Well, most of the provisions expanded fair dealing or user rights. Fair dealing expands to include education, parody and satire. Private copying is allowed, so format and time shifting. So if you have a copyrighted work in one particular format, say a CD, it is legal to transfer it to another format or to make a copy so that you can watch it or listen to it later on. Non-commercial user-generated content such as fan-made trailers or videos is allowed in Canada. We have notice and notice, which is considered good for user rights in contrast to notice and takedown. So notice and notice means if someone thinks that you have violated copyright, they may tell your internet service provider, and the internet service provider tells you that someone says that this is a copyright violation. This is considered better than the other regime, which is notice and takedown, in which a copyright owner can talk to the ISP and say that's a copyright violation and the ISP needs to take it down, and the person who posted the work, whatever, has no opportunity to say, well, no, that's not actually a copyright violation. The bad news from the user perspective is that protection is now available for digital locks, so that if you have to break a lock to use copyrighted works, whether the use is legal or not, it is illegal to break the lock in order to use the work. There's a lot of case law recently and currently going on in Canada. In 2004, a major case is the CCH versus Law Society of Upper Canada. Basically, the CCH, which is a law publisher, sued the Law Society of Upper Canada because they were making copies of articles out of journals that they had purchased and sending them to their lawyer members. Well, the Law Society of Upper Canada won this, and this was a major assertion of positive fair dealing rights in Canada. It said that Law Society members had a right to copy articles that the library had paid for them for their own personal use, and that the library staff were okay to do the copying for the members. In 2012, within a very short time of the Copyright Modernization Act, there were 5 Supreme Court decisions that were in favor of fair dealing in Canada. There was a positive thing that fair dealing should be treated as a positive user's rights as opposed to just an exception or special case, as is mentioned in Byrne. Fair dealing was expanded. For example, private study can include teacher instruction, so not just you're deciding to do some studying on your own, but if I'm teaching you so that you can do some private studying, that's covered too. There is technical logical neutrality. So if I pay fees to use a copyrighted work and then I want to use it in a different technology, I don't have to pay a separate fee for that. A different type of case law, the Freelance Writers versus Thomson News Corporation from 2004. A class action lawsuit was launched by a freelance writer, Heather Robertson, in 1995. So 1995 to 2004, you can see that things that go to the Supreme Court eventually can take a very long time. What was this about? Well, the freelance writers felt that when they were writing for a newspaper, and this was a context of mostly print newspaper, that right does not extend to online databases and the freelance writers one. This is also called Canada's Tassini because there was a similar case in the US before this. Michael Geist, who is one of the professors at the University of Ottawa and cross-appointed to ASIST, had commented on this in his blog if you're interested in knowing more. The Copyright Board and Copyright Collectives are the last piece of copyright and how it works in Canada that we're going to cover today. The mandate of the Copyright Board, it is an economic regulatory body. That means that they create regulations having to do with money, that they're empowered to establish either mandatorily so they can make people pay for stuff, or at the request of an interested party, royalties to be paid for the use of copyrighted works when the administration of such copyright is entrusted to a collective administration society. So, here's an example of a collective society tariff or royalties and how it works. Let's say you want to teach a fitness class in Canada and you want to use music, including commercial radio, to go along with a fitness class. Well, you need to pay a tariff for that, for background music, $1.23 per square meter or $11.46 per square foot. There's a minimum fee of $94.51. In information professions, two very famous case laws of examples in copyright involving copyright collectives are the Access Copyright versus York University lawsuit, which is still in progress, and the Copybeck versus Laval University, which has been settled. So they're very similar, but as we learned before, there are two different legal systems in Canada, common law and civil law, and so there are two different copyright collective societies that work under these slightly different ways to approach judicial decision making in Canada. So what is going on with these and why is this happening? The collectives want a compulsory license. So for example, with universities, they want universities to make a payment for every student so that they can distribute it to their members. Recently, they had a very high proposed price increase and also extensive auditing requirements. For those two reasons, many universities had said no. This has been very good for the information professions because it's created a lot of copyright librarian positions. In conclusion, copyright in Canada is governed by legislation and case law. Litigation or lawsuits in this area are quite common. Canadian user rights expanded in 2012 with the Copyright Modernization Act and 5 decisions of the Supreme Court. However, the Copyright Act is currently under review, so who knows what might happen next. So next up, there are some exercises to go with this video.